This is a lecture for my professional responsibility course, and we're going to be talking about a small and somewhat obscure rule, and I'm hoping this is going to be a really short video. We're going to be talking about 3.9, which is the last of the advocacy or litigation rules. And we would probably call the whole cluster of rules 3.1 to 3.8 litigation rules, except for 3.9, which is being an advocate in non-adjudicative proceedings. And here's the rule, and this is the only slide for this video. I'm not even going to go to the comments. I would encourage you to take a peek at the comments before the MPRE. The only tricky thing about this rule is that the way it incorporates a number of other rules by reference and could implicate those other rules by reference. And that's the only thing that's really tricky here. So a lawyer representing a client before a legislative body or an administrative agency in a non-adjudicative proceeding shall disclose that the appearance is in a representative capacity and shall conform to the provisions of rules 3.3a through C, 3.4 A through C, and 3.5. And so we're talking about things like candor to the tribunal and fairness to other parties, like not destroying evidence and not disrupting the proceedings. So it's not uncommon. This is something that lawyers sometimes do for clients. You have a client who hires you to essentially to lobby, but it could also just be that you're their client and there's a legislative hearing, and this could be a congressional hearing or state legislative hearing. Also, regulatory agencies, when they have they're considering promulgating a new regulation, will often hold public hearings, and the regulated industry will send their lawyers to testify and to weigh in on what they think the rules should be like, or something like that. If you do that, this is pretty simple. Number one, you don't pretend that you're just there as a concerned citizen if somebody's paying you to go there and be their mouthpiece, right? And so that's all the rule says, is when you are going to go testify at a congressional committee or subcommittee, or if you have a regulatory agency that's holding public hearings about some pending regulations, or maybe amending pending regulations. We have hearings in my state right now. There's hearings with the bar about rescheduling the bar exam and diploma privilege and things like that. And so if you are representing someone and you're going to speak at one of these hearings, you need to be upfront and disclose that you're there representing someone and not just speaking on your own behalf, right? And then remember, candor to the tribunal. You don't get to destroy evidence. You don't get to lie if you're testifying before Congress and they ask you a question, and all of those other things from 3.3, 3.4, and 3.5. That's it for Model Rule 3.9.